Judgment in the matter of McCue against Glasgow City Council.
Lord Sales will hand down this judgment.
This case is about the provision of community care services to disabled persons by a local authority, the council, pursuant to the Social Work Scotland Act 1968, and about the effect of the Equality Act 2010 in relation to that provision. Specifically, the case is about the powers of a local authority to levy charges for the provision of community care. The appellant is Mrs. Terry McCue, acting as guardian for her son, Andrew McCue. Mr. McCue is 27 years old. He has Down syndrome and he lives with his parents. He is provided with community care services by the council. The appellant accepts that the support plan provided by the council is appropriate and lawful, but she says that the charges levied by the council in relation to it are too high. Mr. McCue's only income is from various social security payments, which are designed to help him live with some independence despite his Down syndrome. The appellant says that the charges levied by the council eat up too much of Mr. McCue's income, and so unfairly undermine his ability to live a life which is as independent as possible. This is because, in calculating the amount of Mr. McCue's income, which is available to be taken into account for the purposes of charging him for the community care he receives, the council has not sufficiently taken into account and made deductions in respect of sums which Mr. McCue has himself spent on coping with aspects of his disability. The appellant says that by setting the charges at a level which does not make due allowance for Mr. McCue's own expenditure on disability-related items, the council has breached its duty under Section 15 of the Equality Act, in that it is treating Mr. McCue unfavourably by reason of something arising out of his disability. The appellant also says that the council has breached its duty under Section 20 of the Equality Act, in that it has applied a policy or practice which is disadvantageous to disabled persons and has failed to make reasonable adjustments to correct that disadvantage. The appellant failed in her claim on behalf of Mr. McCue at first instance and in the Court of Session on appeal. She now appeals to the Supreme Court. This court unanimously dismisses the appeal. It holds that the council has acted lawfully in setting the charges to be levied for its provision of community care services. The council has power granted by Section 87 of the 1968 Act to levy reasonable charges for providing community care services. In doing so, the council is entitled to take account of the income Mr. McCue receives from welfare benefits. The council has to calculate what part of Mr. McCue's income is reasonably available to meet such charges. In doing that, the statute states that the council may not charge more than it appears to them that it is practicable for him to pay. The object of the statute is to ensure that a fair balance is maintained between the person's private means and the public purse, so far as bearing the cost of provision of community services is concerned. It is in relation to the council's application of this rule that the appellant's complaint arises. In calculating Mr. McCue's income, which is available for the purposes of levying charges upon him, the council accepts that certain disability-related expenditure of his is concerned with items which impact on him especially directly and unavoidably by reason of his Down syndrome. They have reduced their assessment of his available income and hence the amount of the charges accordingly. This is on the basis that it is not practicable for Mr. McCue to redirect the sums spent on those items in order to meet charges for the community care provided to him by the council. However, the council has declined to go further in making deductions when calculating Mr. McCue's income available to meet the charges. Although Mr. McCue has spent other sums in various ways to counter the effects of his disability and to help him live a more independent life, the council says that these have been discretionary items of expenditure, which were matters of choice rather than of critical necessity. Therefore, in relation to the sums representing this further expenditure, the council considers that it is practicable for Mr. McCue to use them to meet its charges in providing community care. For this reason, it has not reduced its assessment of his available income by the amount of those further costs, and accordingly has not reduced the charges it levies to take account of those costs. The appellant claims that this is wrong. She says there are many other items of disability-related expenditure by Mr. McCue which ought to have been deducted in the calculation of his income available to meet the council's charges, and that this should have had the result of reducing the amount of the charges levied from him. The appellant's case on this is based solely on the Equality Act. She accepts that, subject to her case based on the Equality Act, the assessment by the council of what it is practicable for Mr. McCue to pay is a lawful assessment, having regard to the circumstances of the case. This court does not accept the appellant's case based on Section 15 of the Equality Act. The test under that provision of whether Mr. McCue was treated unfavourably by reason of his disability raises two simple questions of fact. What was the relevant treatment, and was it unfavourable to the claimant? The relevant treatment in this case was the council's decision regarding the amount of the deductions to be made in calculating Mr. McCue's available means, and consequently its calculation of the sum that was practicable for Mr. McCue to pay for the services provided by the council. The council charges both disabled and non-disabled persons under Section 87 according to the same basic scheme. The council extends this general approach in a way which is more generous to disabled persons to take account of disability-related expenditure, being certain non-avoidable costs over and above those which non-disabled persons have to bear. Therefore, the council's approach cannot be said to be unfavourable to disabled persons. In fact, it is favourable to them, since it allows for a greater range of possible deductions to be made in calculating their available means when the council assesses the charges which it is practicable for them to pay. The real thrust of the appellant's complaint is that the council's treatment of Mr. McCue was not generous enough, even though it applies an approach which benefits persons with disabilities. But this is not a proper ground of complaint under Section 15. The court also dismisses the appellant's appeal based on Section 20 of the Equality Act. In order to succeed under that section, the appellant needs to show that a provision, criterion, or practice of the council puts Mr. McCue at a substantial disadvantage in relation to a relevant matter in comparison with persons who are not disabled, in order to be able to say that the council must take reasonable steps to avoid that disadvantage. The council has adopted a practice according to which expenditures are rejected as deductions in the calculation of Mr. McCue's available means if they do not relate to disability, or if a person receives a benefit to meet the cost in question, or if the expenditure represents discretionary spending and is not necessary to meet the disabled person's needs. This practice only applies to disabled people, and so cannot be said to put a disabled person at a disadvantage in comparison with non-disabled people. Since it is a practice that does not allow for any comparison to be made with the treatment of non-disabled persons, there is no scope for the application of Section 20. Rather, on analysis, it can be said that the practice of allowing the deduction of some, albeit not all, disability-related expenditure confers an advantage on disabled people. For these reasons, the appeal is dismissed.
The court will now adjourn.